Hello, and thank you for attending our webinar this afternoon. My name is Patricia Fraun with the Chicago Area Fair Housing Alliance, and this is part 2 of our 3-part fair housing webinar series for housing counseling agencies. If you were able to tune in last week, we provided information on fair housing laws. Today we will delve a little deeper into fair housing rights for people with disabilities, and next week, January 19th, we will discuss best practices for housing counselors to affirmatively further fair housing. Please remember to register for session 3 if you haven't done so already. Today you will hear from our expert presenter, Ken Walden, who currently serves as managing attorney for civil rights team at Access Living of Metropolitan Chicago. At the end of the presentation, you will have the opportunity to ask questions, but during the presentation, all attendees will be on mute. You can type your questions into the chat box, and Ken will address those at the end. We will also make presentation materials available after the webinar. Thanks to Illinois Legal Aid Online for their technical assistance, and this webinar was supported in part by funds from the Illinois Attorney General National Mortgage Foreclosure Settlement. I will now kick it over to Ken for his presentation.
Thank you, Patricia. So for today's hour or so, I'm going to try to provide very basic knowledge of the fair housing rights of people with disabilities. We will be moving somewhat quickly. We will not cover everything you ought to know about this subject, but we'll again cover the basics. The training will be based on hypotheticals that you'll see in a few moments, which are all based on real cases we've handled in our office. Usually this training is an interactive one, but because of the nature of this training, rather than asking questions for you to answer, I'll ask them for myself and then answer them in turn. After the training, a handout will be available with the answers to all the questions I ask and additional hypos as well. So I'd recommend that after the training you spend maybe 15 minutes or so or 20 minutes or so reading that entire document, because it will provide much more information that I could compact into this hour presentation. So let's move right along. First, a commercial, a very brief commercial about Access Living. Access Living is a disability rights organization. It's governed and staffed by people with disabilities, which means most of the people who work there and most of the people on our board are people with disabilities. So we feel we have a kind of a unique perspective on disability rights and the fair housing rights of people with disabilities. We've been around for about 30 plus years, and Access Living, among a number of programs and services, has a legal team which I direct, which provides advice, counseling, and representation to folks with disabilities who have fair housing complaints. As you probably learned last week, the Fair Housing Act was originally passed in 1968. When it was passed, it became illegal under federal law to discriminate against the following protected classes: race, color, national origin, religion, and gender. Notably, however, disability was not included at that time. It wasn't until 1988 that disability was added as a protected class, which I think is rather remarkable. That means that until 1988, it was not illegal under federal law to discriminate against a person with a disability. So, until that time, a landlord, a housing provider, could refuse to rent to someone because he or she used a wheelchair, had a vision disability, deaf, etc., and that was perfectly legal at the time under federal law. But the Fair Housing Amendments Act of 1988 changed all that. And with respect to disability, it did something unique. Previously, with respect to all the other protected classes, the Fair Housing Amendments Act's requirements are all theoretically kind of premised on a thou shalt not. So thou shalt not refuse to rent somebody based on the color of his or her skin, or gender, or national origin. But when disability came along, Congress passed thou shalt provisions, which are affirmative obligations that housing providers must perform to promote equal opportunity in housing for people with disabilities. And we'll address some of those thou shalls as this training continues. All right, so now it's time for hypotheticals. So let's move right into the first one. Peter. Peter shares custody of a dog with his ex-wife. Peter lives alone in an apartment building that has a no pets policy. The building has told Peter he cannot keep the dog. Peter states that he has obsessive compulsive and generalized anxiety disorder. He claims he needs the dog because it provides emotional support that diffuses his anxiety and obsessive thinking, especially at night. Peter is a teacher at a suburban high school. He is also a part-time actor who has appeared in plays throughout Chicagoland. He states that he does not take his dog to work or when he is acting. Peter wants to keep the dog. So what can Peter do? Under the Fair Housing Act, Peter can ask for what's called a reasonable accommodation, which is an exception to a rule, policy, practice, or procedure of the housing provider. Here, that policy is no pets. The apartment building does not allow any pets, and Peter wants an exception to that rule, which is kind of a classic accommodation request. But the facts here are somewhat mixed. Does Peter have a good case? And you might be a little skeptical. We were too when we initially got this case. First of all, he shares custody of the dog, so he doesn't need the dog all the time. He doesn't take the dog when he's teaching. He doesn't take the dog when he's acting. And he especially needs the dog at night. And so one might think that Peter doesn't really need this dog. And in order to get a reasonable accommodation, you have to need the accommodation. But when in our office we started to think more closely about this case, we saw that there was merit to Peter's claim. What's unique about his situation? Perhaps you've noticed that when Peter is alone at night, that's when he especially needs the support dog. Also, remember that many disabilities are episodic in nature. For example, mental illness, autoimmune disabilities, some physical conditions, seizure disorders, and the like are often episodic, meaning they don't occur all the time. And here with Peter, his issues, his mental illness, is not necessarily manifest all the time. But at night when he's alone, not surrounded by other people, is when he experiences issues. So if Peter's going to claim to the housing provider that he needs the dog for support, does the housing provider have to rely merely on Peter's word? In other words, does Peter have to provide any documentation to demonstrate that he truly needs the dog? In this instance, because the need for the dog is not apparent, Peter would have to provide some type of documentation. Normally, the type of accommodation that's provided for an accommodation that's not an apparent one is some type of note from a doctor, a therapist, a social worker, and the like that explains the need for the animal. In this case, we got a note, we got an affidavit from his therapist that explained he truly did need the dog when he was alone, especially at night. And with the strength of that letter, his accommodation was approved by the housing provider. A lot of housing providers wonder, and a lot of housing counselors wonder, whether a dog has to be specially trained to perform a skill in order to be or to qualify as an accommodation. The short answer is no. A dog does not necessarily have to go to a special school or get special credentials to qualify as a support animal. Other questions that folks often ask are whether or not a landlord can impose a pet fee. The answer is no. Any additional deposit for the animal? The answer is no. Whether the landlord can increase the rent because of the presence of the animal? The answer is no. And whether the landlord can compel Peter to purchase special liability insurance for the dog? Again, the answer is no. That's the case with respect to pet fees, even if we change the scenario a bit, and this is a complex that allows pets. Even if the complex allows pets, if a person with a disability, here Peter, needs the dog as an accommodation, the pet fee should be waived. Other questions come up in these scenarios often. What about any restrictions on the dog? Can the dog go anywhere about the building? And the answer is, again, a resounding no. In most instances, a housing provider cannot put any restrictions on the dog. But that's qualified by some reasonable behavior. For example, in some instances, if residents are known to be fearful of dogs, it would be Peter's obligation to perhaps keep the dog away from certain areas when those folks are around. Commonly that comes about in elevator situations. Follow-up question. What if Peter's dog was not providing emotional support, but was a guide dog? In that instance, obviously, this would be an accommodation to the no pets policy. But what's different here is that in this instance, Peter would not have to provide documentation from a therapist, a physician, social worker, and the like to demonstrate the need, because the need is apparent. So let me kind of summarize that again. In Peter's situation with the support animal, because the disability was not apparent, he needed to provide some supporting documentation to demonstrate the need. But if Peter's situation was different and he had a visual disability and needed the dog for guidance, for walking and ambulating about, in that instance, the housing provider would not be allowed to ask for documentation to prove the assistance provided by the animal, because the assistance is readily apparent. Also, you might note that in these instances, typically, unlike the emotional support animal, the guide dog is obviously trained, but again, it's going to be obvious that the guide dog's been trained, and again, the housing provider cannot ask for credentials regarding the dog's background and training. What about other animals? Can other animals qualify as support animals? And the short answer, is yes. It could be a cat, it could be a ferret, it could be just about anything. But again, in this instance, if the need is not apparent for the animal, Peter would have to provide supporting documentation. All right, let's move on to the next hypothetical. Keisha. Keisha has a physical disability. She has lived in her apartment building for several years. Until recently, Keisha relied on a cane or walker to move about. However, her condition has worsened over time, and she now uses a wheelchair. As such, she has great difficulty getting through the main entrance because it has a couple steps. What can Keisha do here? In this instance, Keisha can ask for what's called a reasonable modification. Reasonable modification is typically a structural change that would enable Keisha equal opportunity to enjoy her tenancy. So unlike an accommodation, a reasonable accommodation, which is a change to a rule, policy, practice, or procedure, a modification usually involves some type of infrastructure improvement to enable equal access. So here, Keisha seems to need a ramp, and she can ask for a ramp as a reasonable modification. Question always comes up as to who has to pay for the reasonable modification. And again, the short answer is this. If this is private housing, then the obligation is on Keisha to pay for the ramp. The obligation is on the housing provider to approve the ramp because this is reasonable, but the obligation is on Keisha to pay for the ramp. However, if this is subsidized housing, if this is housing that receives federal funding, then the obligation is on the housing provider to pay for the improvement. And that's a separate law called Section 504 of the Rehabilitation Act that requires the housing provider of subsidized housing that receives federal funding to pay for modifications as long as the cost is reasonable. Is any paperwork required for CAFHA? Yes. The landlord would be entitled to ask for a reasonable description of the work, reasonable assurances the work will be performed in a work-person-like manner, and that any required permits be obtained. So it would be on CAFHA to provide this information to the property owner or landlord. Who maintains the ramp? If a modification like a ramp here is to a common area, then the obligation is on the housing provider to maintain the ramp. However, if the modification is to the unit, for example, a common modification in the unit is maybe widening doors or putting up a grab bar, and if there's any maintenance that needs to be done with respect to especially a grab bar and the like, then the obligation would be on CAFHA to maintain that improvement. Now, what would happen if CAFHA did not yet live in the building, but was planning to move into the building? Did not live there yet, however. Is this the same result? Can CAFHA ask for modification even if she doesn't yet live there? And the answer is a resounding yes. She can still ask for the modification. The obligation would still be on her to pay for it, but she can still ask for a modification before she's actually moved into the building. And we've had cases like that where a family member has asked for a modification for a child after having engaged to move into a unit. All right, let's move on to our next hypothetical, Maria. Maria has an autoimmune disability. To treat her condition, Maria takes medication. She lives in an apartment building. One of Maria's medications makes her sleepy. Recently, due to this medication, Maria fell asleep while cooking something in her oven, which caused a small fire. Maria woke up in time to call the fire department, which put out the fire. However, the oven was damaged and there is smoke damage on the walls and ceiling of the kitchen. Due to this incident, management sent a notice to Maria that states it intends to evict her for breach of the lease. What can Maria do? Again, Maria can ask for what's called a reasonable accommodation to the housing provider's policy of eviction, because the fire here was attributable to her disability. Must manager discuss this request with Maria, even though it may initially be worried that Maria's tenancy might be a risk to Maria and other residents in the building? The answer is yes. The housing provider has an obligation to engage with Maria or anyone who asks for an accommodation, and this is called engaging in the interactive process, in an attempt to resolve the conflict and see if an accommodation might be provided that would solve the problem. Here, that problem being the fact that Maria has potentially going to be a risk to the building. And again, we have had cases like this as well, where initially we thought, this is a tough case. Maria caused a little fire. It's a little dangerous. What can we do? And during the interactive process, we came up with a few solutions in various cases. One solution was to permanently turn off the oven. Another solution was to have a personal assistant or aide cook meals for our client. And in another instance, we had a case where our consumer, our client, got different medication that did not make her sleepy. And as a result of those changes, we were able to persuade the landlord to accommodate our client and confirm her remaining in the building. Let's move on to Amber. Amber, who is blind, is interested in a third floor apartment in a building that does not have an elevator. When Amber shows up to view the unit, the landlord notices Amber's disability. The landlord is concerned that Amber may hurt herself walking up or down 3 flights of stairs or be unable to exit quickly in an emergency. The landlord is also worried that she may be liable if Amber gets injured. Therefore, the landlord refuses to rent the apartment to Amber. Can the landlord do this? No. The landlord would be denying housing to Amber based on her disability. It is Amber's call where she can live, not the housing provider's, even if in this instance the housing provider says that she means well. Amber's right to make decisions free from the housing provider's paternalistic and discriminatory attitudes is paramount. Also, the landlord's fear of liability is not a basis to deny housing to Amber. A lot of folks get this question wrong when we do an interactive training, but please know that it's, in this instance, as in any instance, it's the consumer's call as to where they feel comfortable living. Let's move on to Letitia. Letitia has a physical disability. She lives in an apartment building. She usually relies on a cane or walker to move about, but sometimes uses a wheelchair. The apartment building has a parking lot for residents, which includes 3 accessible spaces. Residents are assigned parking spaces. Letitia needs an accessible parking space, but her assigned space is not accessible. 2 of the accessible spaces are used by residents who use a wheelchair, and the remaining accessible space is reserved for guests who have a disability. Can Letitia get the accessible space reserved for guests? This is kind of a classic accommodation request, and the answer is yes. As an accommodation to Letitia, so that she has an equal opportunity to enjoy her unit, the guest space should be given to Letitia as a reasonable accommodation so that she can have an accessible space. However, in parking cases, it's not so easy sometimes. Assume instead, in this scenario, that there are only 2 accessible spaces in the lot, and both are used by residents who use wheelchairs. What happens then? This is often a claim we get when we contact housing providers or landlords about accessible parking. And initially the claim is, we don't have anywhere to accommodate your client. We don't have anywhere to accommodate Letitia. However, often when we engage in the interactive process and sit down and talk with and meet with a housing provider, a solution can sometimes be come up with. For example, sometimes restriping of parking spaces can free up enough space to create an accessible space for Letitia. Rearranging parking spaces can also result in the same. Sometimes simply moving dumpsters or equipment around or storage areas around can create enough space for an accessible parking space. So in these instances, I urge folks to kind of think outside the box and see if a solution is possible. It won't always be possible, but the housing provider has an obligation to engage, to think outside the box and see if a space is available in some way, shape, or form. Franklin. Franklin, who is deaf, recently moved into an apartment building. He relies on sign language to communicate. Management has planned a welcome to the building party for new residents. Franklin plans to attend. He asks management to provide a sign language interpreter for the party. Does management have to provide the sign language interpreter? Again, lots of folks get this one wrong. Management absolutely has an obligation, as a reasonable accommodation, to provide a sign language interpreter for Franklin. What sometimes happens in these cases is that the management says, sure, you can bring your own sign language interpreter, perhaps a family member, but we are not obliged to provide one. However, remember that this is a management function. This is a management event, and management has an obligation to ensure that Franklin has an equal opportunity to enjoy this party. Franklin will not enjoy this party if he can't communicate with anybody. Does he get equal access if he goes to the party and he can't participate or communicate? Of course not. He needs a sign language interpreter so he can participate on an equal footing with everyone else. And hence, in this instance, Franklin is entitled to a sign language interpreter at the housing provider's expense. Let's change the scenario. Let's say a few months down the road that as part of an annual policy, part of an apartment policy, the housing provider decides that it's going to inspect the units of residence, gives proper notice, and wants to inspect Franklin's unit. In that scenario, the inspection can probably occur without a sign language interpreter. And so in that instance, if Franklin were to ask for a sign language interpreter for that type of an event, I generally think he wouldn't be entitled to, because he can probably communicate with management or maintenance by writing notes back and forth and the like, and it's not going to be an intense communication situation. Instead, management is simply going to come in and take a look. And if there are any issues it wants to point out, it can certainly communicate those to Franklin in writing. Milton. So I wanted to provide a hypo that was particular to housing counselors and not housing providers. And so we've got Milton here. Milton visits the office of a housing counselor to receive help with his search for an affordable apartment. He is a veteran. Due to injuries in combat, Milton has very limited use of his arms and hands and impaired vision. He also states that his short-term memory is poor. In this instance, Milton may need reasonable accommodations from the housing counselor, and several laws would require the housing counselor to provide reasonable accommodations. Local law, state law, and national law would require such accommodations. What types of accommodations might Milton need? He might need help filling out forms. He might need materials in large print. He might need reminders of appointments and tasks. The handout that you'll get after the hearing lists other common accommodations that folks might need from a housing counselor. Let me run through those. For folks who are deaf or hard of hearing, a housing counselor might need to provide a sign language interpreter. And remember not to ask the consumer to bring his or her own interpreter, such as a family member. For a person who is deaf or hard of hearing, the housing counselor might be required to permit the consumer to read lips, to write and exchange handwritten notes, to communicate by email rather than by phone, and or provide CART services, which is a service that provides real-time captioning of conversations. If you're taking notes, be assured that you don't have to, as all these possible accommodations will be within the handout. For consumers who have a visual disability, providing materials in braille or large print, or taped or audio tape versions of materials might be an accommodation. Electronic versions of documents, reading documents out loud, and permitting a guide dog in the office would also be reasonable accommodations. For consumers who have a movement-related or mobility disability, housing counselors might be obliged to ensure they have an accessible meeting space, or might be obliged to meet a consumer outside the office or at the consumer's home, or to assist the consumer with completion of forms, for example, typing information while the consumer speaks. For consumers who have a cognitive disability, housing counselors might be required to provide materials and or forms with simplified language, might be required to assist consumers with completion of forms, spend additional time with the consumer to explain certain things and requirements, allow additional time to complete tasks, to divide tasks into steps, and to provide reminders about meetings and appointments. For consumers who have a psychiatric disability, spending additional time with the consumer to explain things, allowing additional time to complete tasks, dividing tasks into steps, accommodating behaviors related to the consumer's disability, being flexible about appointments and meetings, rescheduling them as needed, and permitting an emotional support animal in office. Because we were so successful in running through the hypos, I'm going to add a few bonus hypos in about 5 seconds. Here we go. These are not part of the PowerPoint. These are bonus hypos. Mr. and Mrs. Page live in an apartment building with their 3-year-old son, Thomas. They own a unit on the 3rd floor. The rules for the building require that units on upper floors have wall-to-wall carpeting, except in the kitchen and bathrooms. The couple recently learned that Thomas has severe asthma and is highly allergic to dust, mold, and other allergens. Because carpeting accumulates a lot of allergens and is known to exacerbate asthmatic symptoms, Thomas's physician instructs the couple to replace the carpet with hard flooring. Mr. and Mrs. Page explain their situation to management and ask for permission to install hard flooring. Management is concerned that the absence of carpeting will make it very noisy for the tenants who live in the unit below the couple and therefore denies the request. So again, this is a situation where Mr. and Mrs. Page's son is not going to do well in the unit with carpeting due to severe asthma and allergies. So Mr. and Mrs. Page, as an accommodation, want the carpeting removed. But the building has a requirement that carpeting be installed for noise purposes. Again, this is based on a real case, and they ask for an accommodation. There are a variety of accommodations that can be provided in this situation. For example, instead of wall-to-wall carpeting, the couple could ask management to allow them to place large area rugs on the floor in lieu of carpeting, and, as necessary, clean the rugs, install cork flooring or another type of sound-absorbent flooring, and/or install other sound-proofing remedies. Again, this is based on a case or two we've had, and in these instances, the case is settled with those types of accommodations. Second bonus hypo. Over the past few years, several residents who use wheelchairs, both manual and motorized, and live in an apartment building have scuffed up the walls of common areas. As a result, management plans to charge residents who use wheelchairs an annual maintenance and service fee. Can management charge this fee? To summarize, management wants to charge a special fee to residents who use wheelchairs who've scuffed up the walls of common areas. Can they do this? The answer is no. Management cannot charge a fee that applies only to people with disabilities. Doing so would constitute a penalty for the privilege of living in the building. However, management can charge a resident, including a resident with a disability, for repair costs if he or she caused damage to a unit or common area that is beyond regular wear and tear. Scuffed up walls would likely be considered regular wear and tear, but holes in the walls would likely be considered beyond regular wear and tear. All right, we'll do one more bonus hypothetical. Danielle has a psychiatric disability. Because of her disability, Danielle at times is easily agitated and reacts aggressively to events perceived as negative. Management is aware of Danielle's psychiatric disability. She has been living in her apartment for 7 years. Every couple of months, Danielle storms into the management office to complain about the cleanliness of the building, security, cable service, needed building improvements, and/or certain neighbors. She demands immediately to see the property manager and yells objections that the property manager is not available. She repeats this scenario every few hours until the property manager is available. When she meets with the property manager, she threatens to sue her if the problem is not fixed right away and complains bitterly about how she is treated by management. Also, 3 or 4 times per year, other residents complain that Danielle has yelled at them. Management is thinking about trying to evict Danielle from the building. So here's a situation where Danielle has a psychiatric disability. Management is aware of it, and every few months Danielle storms into the office to complain about various aspects of the building, demands to see the property manager, and yells objections. When she meets with the property manager, she threatens to sue. And then 3 or 4 times per year, other residents complain about Danielle. What are your thoughts? What, if anything, can management do in this instance when management is thinking about evicting Danielle? Under the Fair Housing Act, if Danielle's behavior is attributable to her disability, then before penalizing Danielle, the housing provider must work with Danielle in an attempt to resolve the conflict. Again, this is what we've been calling engaging in the interactive process. For example, the housing provider may set boundaries with Danielle by explaining she may only report an issue once and must do so in a respectful manner. If Danielle's behavior becomes so problematic that the housing provider considers her a direct threat to the health or safety of others or to the property, it still has an obligation to work with Danielle on an accommodation that will eliminate the risk. Let me repeat that. Even if the housing provider is concerned that Danielle's behavior might be considered a direct threat, it still has an obligation to work with Danielle on an accommodation that will eliminate the risk. If no such accommodation is possible, then the housing provider can file to evict. And here you should note that Danielle has not hurt anyone, hurt any property, and as far as we can tell from the facts, she pays her rent on time. In this situation, in our view, the housing provider would be hard-pressed not to provide some type of accommodation that would address the issues of her behavior in a way that would enable Danielle to maintain her tenancy. All right, no more special hypos, bonus hypos, but now I'd be happy to entertain any questions. Oh, you can enter questions in the chat section on your screen. So far, no questions. Oh, here's our first question. Is it a good idea for management to develop policies for reasonable accommodations or modifications? Are there model policies? Great question. Yeah, it's an excellent idea for management to develop policies for accommodations and modifications, policies that are consistent with federal, state, or local law. Are there model policies? There are. I would suggest contacting a fair housing organization to get a model policy, or if there's a local, highly respected real estate entity that has good policy, that's an option. Yeah, for sure that's a really good question. Question 2, how do animal size and breed requirements apply if a person is already living in the unit and it has not yet gotten a service support animal? HUD has issued guidance on this issue. Breed and size restrictions or requirements do not apply as to an accommodation related to a support animal. So if a housing provider forbids, for example, pit bulls or dogs over 30 pounds and the like, those restrictions do not apply when someone's asking for an accommodation related to a support animal. And if you're interested in seeing the guidance on that, it would be easy to find. Google HUD guidance on support animals, and you should be able to quickly find it. Next question. Who can we contact if we have additional questions about residents' housing rights? You can contact Access Living. You can contact a number of other fair housing organizations in your jurisdictions, and hopefully you can get information. Lots of organizations, including ours, have materials that they'd be happy to share with you. We have materials that will be made available to you after the presentation that will probably answer a lot of questions again. The handout will have much more explanation and much more questions and answers than we had time for today. Next question. So I work in fair housing. In the Franklin example, isn't it possible that the housing provider will cancel the community event rather than accommodate with a sign language interpreter? How could this be avoided to ensure all parties have a positive outcome? I'd say, yeah, sure, anything is possible. If the housing provider were to cancel the event because it didn't want to accommodate Franklin, I'd say that probably gives rise to a fair housing violation. One of the housing provider's principal concern is going to be how much this might cost. They'd probably be surprised to learn that sign language interpreters don't cost all that much, maybe in the neighborhood of $150 to $200 for 2 hours. If that's going to be an undue burden for the housing provider, then they wouldn't have to provide the sign language interpreter. But certainly for bigger entities, big property management companies and the like, $200 could certainly be absorbed, and they'd be obliged to pay that cost. But if it's a small mom and pop, potentially maybe $200 might be too much for them and might be an undue burden. I'd say probably not in most instances, but it's certainly possible there might be a case where someone really couldn't afford that type of money, but I kind of doubt it. Next question. In regards to some of the adjustments that have to be done to the construction of an older home to make it more accommodating, are there any agencies that can help with expenses to make the changes? Thank you. If you live in the city, the Mayor's Office of People with Disabilities has a modification fund. The Department of Rehab Services can also sometimes be utilized to pay for modifications needed in a home. We had a case recently where a family lived in a condominium building, the second floor. Their son uses a very heavy motorized chair. When he was younger, it was easy to carry the son up and down the stairs and move him into a manual chair in the unit. But as he got older, that became very problematic, and the family got a grant from the Department of Rehab Services to pay for a lift in the back of the building that would basically carry the son from the first floor to the second floor with his chair. There are some foundations that provide funding. I think there's a foundation called Ramp Up, and I'd suggest Googling to see what's available in your jurisdiction. For the most part, there's not nearly enough modification funding available for folks who need modifications, but there is some, and if you snoop around a bit, hopefully that's something you can leverage for a client. Should requests for a reasonable accommodation be submitted in writing? Absolutely. They don't necessarily have to be, but it makes your life and the life of lawyers and other people who are trying to support an accommodation request. And the timing of an accommodation request much easier if we have something in writing. It's kind of a cliche to say this, but having a paper trail is very helpful in these instances. Any other questions? Oh, here's a question. In the case of the pit bull, would the resident be required to pay for the increase in insurance costs if the insurance company requires an increase with the pit bull in the building? In that instance, I'd say that there's possibly a case to be made that the insurance company has violated fair housing law or some other disability rights protection law. And it's my understanding, I don't have a lot of experience with this particular situation, but I think I know of cases where insurance companies have been sued by fair housing groups for trying to increase insurance costs when a support animal is asked for as an accommodation. Any other questions? We'll wait one more minute. Another question. Can you repeat again the part of who pays for the ramp? Absolutely. So modifications are paid for by the tenant when it's private housing, when there's no subsidy attached to the building and when the building's not receiving any federal funds. The resident is obliged to pay for the modification. When the building receives federal funds, for example, a housing authority or a subsidized property that's subsidized with federal funds, then the obligation is on the government or the housing provider in this instance to pay for the modification. So if Keisha were renting a unit in the private housing market, she'd be responsible for paying for the ramp. If she were renting a unit from the Cook County Housing Authority, the Cook County Housing Authority would be obliged to pay for the ramp. Interesting to note that a parking space, which many think might be a modification, it's actually considered an accommodation under federal law. So a parking space, if there's any restriping, re-signing, movement of equipment, restriping, etc., rearranging of spaces, those costs would be borne by the housing provider in all instances because that's considered an accommodation. And reasonable accommodations like a sign language interpreter and the like, those are provided by the housing provider regardless of whether it's private or subsidized housing, and that includes a parking space. Next question, can you share a scenario when someone has been denied an accommodation and why they were denied? Can you share a scenario when someone has been denied an accommodation and why they were denied? Yes. We have a case right now where a resident who's renting a unit in a condominium building, she received complaints that she was dragging in dirt into the front lobby and in front of her unit door. And the condominium board, again, she's renting a unit in a condo building, complained about the dirt. So she suggested that she be allowed to that they place or that she place carpeting, a kind of a throw rug in the foyer area, and a little rug in front of her unit. Oh, and frankly, there was a third complaint that she was scuffing up the exterior of her door so it didn't look so nice. So she said that she would be willing to place a carpet in the foyer, a carpet in front of her door, and put kind of an opaque, transparent plate on the bottom of her door. In that instance, just so you know, I think that's probably an accommodation case, but in any event, she agreed. She actually had some support to provide the stuff, to pay for it. She agreed she'd provide these things. And inexplicably, the condo board said, no, we will not allow you to do this. At that point, we filed a complaint, and a couple months later, the housing provider condo board came to its senses and agreed that she could get all those accommodations. And at this point, now we're negotiating. They're having to pay damages and attorney's fees to us because they acted, frankly, so dumbly by denying those obvious needed accommodations. The reason for denying the accommodations initially were that it wouldn't look so nice, and they didn't want this transparent plate on her door, to which we collectively in our office kind of rolled our eyes and said, that is so dumb. And so we filed a complaint, and now, rather than taking the easy way and providing the accommodation right away without having to deal with the lawsuit, now they're having to do it, make all the accommodations we asked for, plus pay damages and fees. Not so smart. Good question. Next question. What happens when there is no accessible parking space available in a lot for a building and none of the creative solutions you mentioned work because it's a small lot? Also, how is that affected by parking spaces being deeded with a condominium purchase? That's an awesome question. All right, if there's no space to be had, even when everybody puts on their thinking caps, then there's no accommodation to be had. And in that instance, if there's nowhere to place an accessible space, there's not a whole lot you can do. In a situation where spaces are deeded, that question is addressed in the handout, and this is how we would answer it. It would be the responsibility of the housing provider to engage in the interactive process and attempt to come up with a solution. Possible solutions the housing provider might employ include asking the residents who own the accessible spaces to switch spaces with Letitia, either through a formal transaction or some type of lease or license agreement, moving dumpsters or equipment or otherwise modifying the parking area to create an accessible space. Again, that may or may not be possible. Or purchasing the next accessible space that goes on the market and leasing or licensing that space to Letitia, while at the same time, Letitia gives the housing provider the right to lease or license her deeded space. Hope that makes sense. Again, that's spelled out in the answer to the hypo. You should know that there have been cases around deeded spaces that have been brought by attorneys in Illinois. And the theory is that even if the spaces are all deeded, the condominium association and the developer had an obligation to figure out a way to kind of segregate or quarantine those spaces from being sold so that in the event someone with a disability needed a space, they would have it available. That case settled, but you should know that there is an argument that even in those instances, condo board could be compelled to provide some solution to the fact that all the spaces are deeded, including those that are accessible. Any other questions? These are great questions, by the way. Now that marijuana is a legally prescribed medicine in Illinois, can someone with a prescription be prevented from smoking if it is a smoke-free building and/or it affects another tenant? I get a lot of complaints about marijuana smoke in a building. I'd say the answer is the same for marijuana smoke as it is for regular cigarette smoking. Um, um, and I'd say someone could be prevented from smoking in most instances. I suppose they could ask for an accommodation. That's a really good question. I'm a little bit stumped on that one. I think they could ask for an accommodation to the smoke-free policy. I think that'd be a tough road to hoe, but I suppose it's possible. And if their smoking doesn't really affect anyone else, it might be okay. If it does affect someone else, that effect can't just be speculative. So let me give you a related example. Sometimes we hear from housing providers that they don't want to approve a support dog in an animal in a building because someone in the building is allergic to animals. We've never had a case where we weren't able to overcome that problem by some way, shape, or form. Also, if the person is claiming they have an allergy, that has to be proved. And to date, we've never seen anyone submit proof that someone has such a severe allergy that they can't be in the same building with the dog. And usually there's some way, shape, or form to get around that. But this question about marijuana is a good one. In the context of federal or subsidized housing, it becomes more difficult because marijuana is still considered under federal law a controlled dangerous substance. And so I think in this instance, if you have a consumer who's in subsidized housing, it's going to be hard for them to get an accommodation to be allowed to smoke marijuana. In a private building, I think it's an open question if someone needs marijuana to serve their disability as to whether or not they'd be allowed to do that. Unlike cigarette smoke, I don't know that we've established damage, to secondhand marijuana smoke, but I just don't really know. This is a great question. I just don't really know the answer, but I'm sure we'll be seeing cases of this kind come up. So I hope, I know I was kind of all over the place on that question, but I hope provided some help. Any other questions? All right, Patricia Fraun is going to close us up, but thank you so much for your time. Thank you for the wonderful questions. I enjoyed the presentation, and now I'm going to hand it over to Patricia.
All right, thank you, Ken, and thank you for joining us today. We hope that you will also join us for session 3, which is the final in our series. This will take place next Tuesday at 2 p.m. and will focus on the role of housing counselors in affirmatively furthering fair housing. I will follow up with registration for the next webinar. I will also provide a link to materials from today and a link to a survey to get your feedback regarding today's webinar. So please look out for that email from me, and thank you very much.